All right. Did you guys make it? Can I get one of my socks now? Can I let go of my socks now? Yes. All right. All right. Good, good, good. Walked over. Shirley. Jenny, I think about his change of venue. Yes. Momo. Shark. Hit that thumbs. Yep. Mandy, where are we going? I wasn't paying attention. We're going to Billy. Landed safely. Tammy E. Good, good. All right, cool. Fanny Pack. Therapist you know. Tammy and KS. Julie. Awesome. OnlyFan. That was a nasty jail cut. OnlyFan, you're the first. Jenny was the second. Therapist last. You cheated. Ah. All right, cool. Baca, everybody's getting here. Where are we going? Oh, Mandy, yes. This is now Billy's trial. So, hearing, I'm sorry. Hearing. Billy's hearing. Billy's hearing. Please check the lost and found. All right. All right, so we can, here we go, right back to this. We're quarters on a short break, but they should be coming back in about 6 or 7 minutes, let's hope. Brenda made it. Nice. Candy Kitten made it. Oh, therapist, you know, found somebody's goggles. Audio was good. Thank you, Julie. Appreciate that. I'm here, but under my own steam. Gordon, portal never works for me. Oh, that stinks. I'm sorry. Sorry, Gordon. All right, so now we are going to be picking up on Ohio versus Wagner. This was going to be Billy Wagner. And this is theoretically his last pre-trial before his trial is supposed to start on the 6th of January. Excuse me. Oh, yup, yup, yup. Jeez. Come here, you silly girl. So we just watched, for those that were with us, we just watched the sentencing of Billy's wife, who is Angela. She got 30 years. Billy's son, Jake, who got 8 life sentences, but is eligible for parole after 30 years or 32 years. Very strange because he was the trigger man. And then Angela's mother, Rita, who just forged some documents, and she basically got time served, so she didn't have to spend any time in jail. So that's what we just watched. Did you guys hear that? Oh, my goodness. Meow. Tell me all about it. Polly. Meow, meow. Meow. Oh, meow. Can you guys hear her? Jennifer, you got lost in the portal. Dwayne, are you here? Are you with us? Dwayne.
For like a second.
Oh, Dwayne. Hey, Christine Aitken. Good to see you. Polly. Yeah. Let go my Christmas hooch. Yeah, kitty, kitty. Sarah Ann Schockenhor. Hora. That's Polly. And Rafa's back there. That's Rafa. Wait, Rafa's there. Polly's over there. Hi, Polly. Whoop. Hi. Hi.
She's really.
She's being very vocal right now. Isn't her little squeak?
I know.
Her little
She wants
squeaks.
to go out.
Jennifer, you had to go and find the new feed. Yeah. Sometimes it works, sometimes it doesn't. Yes, you can hear the little meows. Her name is Polly. That's Polly, and this is Rafa back here. Here, I can make this.
She really wants to be friends with
So that's Rafa, and here's Polly. Hi. Oh, meow, 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 meow.
Oh boy.
Oh, boy.
She really wants to be friends with.
All right, all right. That Super Ball growling at her. Hi.
Oh, on the keyboard.
No, not on the keyboard. Don't go on the keyboard. Hi. So this is what I have to deal with. Cuteness overload. Oh, cuteness overload. Sweet little wampum. Okay. Let's go, girl.
Precious bean.
Precious little. Yeah. Hi. All right. Let's focus on what's coming up here. So this is Ohio versus Billy Wagner. This is Trial TV Live, and I am the Squeegee of Justice. Thank you for joining us. We just finished watching the sentencing of Angela Wagner, Jake Wagner, and Rita Newcomb. They were 3 people that were involved in the offing of 8 people of one family back in 2016 in Ohio, Pike County specifically. So now Billy Wagner is the father, husband to, so he's the father of Jake and George, who have both been sentenced. George went to trial, and he was found guilty and sentenced to like 8 life in prisons without parole. And then his brother Jake, Billy's other son, who was the actual trigger man, he was just sentenced to 8 life sentences, but he has the possibility of parole after 32 years. So that's kind of interesting, right? Trigger man gets life but has opportunity of parole, and the other brother, who I don't think did pull the trigger, does not get any parole. And then mom, Angela, that's Billy's wife, she got 30 years, just straight up 30 years. And then her mom, Rita, got time served, and she was forging documents. So Jennifer, still in a state of shock, still in shock of Jake's sentence. Yeah, I can't believe that he gave him the possibility of parole because of what he did. I guess basically he testified against his brother. Let's hope the camera work is a little bit more calm for this hearing. All right, I'm going to go silent. Looks like we got some movement coming in.
Very happy. Very happy. Go ahead, relax. Okay. If you're ready to go, yeah. You need things.
Sandwich to the next door.
Pardon me?
Sandwich to the next door.
No, good idea though.
For hot dogs, if they head downstairs, wasn't it? Whatever, I wasn't going down there, and I was like,
You're in the next spot.
When the lawyers come in this morning, have a flat tire on the way down. So you know something like that's going to happen. Inevitable.
Well, the good news, she had her wedding.
Audio, is it okay? Okay.
Yeah.
yes, I do. I work with him all the time. Yeah, Bernie. Yes, I do. I know him well. He's on the side. Right. Works.
Okay, go ahead and have seats. Right, 2018 CR 157, State of Iowa versus George Wagner III. Set for motion hearing today. Mr. Collins, Mr. Hayes, Ms. Anstead, Ms. Stevens are here for defense. Mr. O'Brien, Ms. Knapp are here for the state. I think there's two matters for the record. First is the defendant's motion from last December, renewing a motion regarding other acts testimony. So it'd be like the scope of admissibility. And then the court's wanting this to hear re-argument with regard to the death penalty specifications. So we'll try to knock those two things out of the ballpark here. I don't know, Mr. Collins, Mr. Hayes, you want to talk about your motion? I think it's pretty much oral argument, but maybe it's hearing written evidence.
Thank you very much. I please support on behalf of our client, Your Honor. We received the government's response to 12:36 last night. I didn't look at it until this morning about 8:30. So with the court's indulgence, we kind of split this up. We're going to let Stevens make the argument, the oral argument. But I guess would you? I'm sorry.
I didn't see any of it yet, so you're still ahead of me.
Okay.
Go ahead.
Would you like a copy?
They're probably just going to get in the way, so we're good. It might have been filed. I just don't get things because I don't have a
I thought
stamp.
I'd email it to you at the same time.
You emailed me
them.
at 12:36 last night. It's in my inbox. I left to get here at 6 this morning. No problems. I just don't live on the web.
Metro.
Yeah, like I'm good with all complaining. I'm not finding fault with anybody.
Oh,
I'm just saying you're ahead of me.
is that coming up?
I read the motions. I looked at the transcripts from the past.
Okay.
I'm already trying to formulate a plan of attack.
May I approach?
Yeah, please do.
There's no writing on there.
Appreciate it. Thanks.
So I guess with the court's help, Your Honor, we didn't know, Ms. Pinappa, the government broke it up into chunks and argued 7 or 8 other acts.
It has handwriting on it. So
Oh, I'm sorry.
Do that.
Sorry about
Thanks.
that.
Thank you.
You would be able to read mine. The government, Your Honor, took each concept in different chunks, and there's maybe 7 to 10 other acts in each of the chunks. So we either argue in chunks, Your Honor, or in big areas, or if you'd like us to go through every single other act, we're prepared to do that as well. That they listed from the February of 2021. So Ms. Stevens can address that, or we could talk about each one, whatever the court would entertain.
I should just start locally, chunks, if you will.
Okay.
Thank you very much, Your Honor. May I proceed?
You sure can.
May it please the court. Firstly, Your Honor, the state of Ohio's response relies on a Supreme Court case decided in 2020, State v. Hartman. And we would submit, Your Honor, that the Hartman case is absolutely instructional for this case because it held that that other act evidence was inadmissible. Evidence of the same character that we submit that the state is seeking to introduce with this other act evidence. In addressing, Your Honor, the state's first chunk of an argument, it uses identity. And it uses identity as an umbrella argument, stating that identity is an issue in this case. However, Your Honor, we would submit that just because identity is an issue in this case, it's not a license for a prosecutor to introduce any type of allegation going back in perpetuity against a defendant. And that's what we have here. The state of Ohio has evidence in the record contrary to modus operandi or the identity of the other act evidence in which it seeks to introduce. In the Hartman case, Your Honor, the Supreme Court held that similar act evidence is only relevant. Thank you, Your Honor. I apologize. In the Hartman case, the Supreme Court held that similar act evidence is relevant only if the jury can reasonably conclude that the act occurred and the defendant was the actor. In almost every other act that was listed in 2021, our client, Your Honor, Billy Wagner, was not the actor of the other act evidence that the state of Ohio seeks to introduce. And the state has evidence, Your Honor, evidence in the record that Billy was not there. Billy was not present for this conversation. Billy did not threaten. That Billy lived with his mother at the time that the state is seeking to introduce these other acts. Identity, Your Honor, as the court is aware, is a permissible purpose under 404B when there is a modus operandi, when there's evidence, indicia of modus operandi. We would submit, Your Honor, that none of the information, none of the other act evidence that the state has provided conforms with, shows that there's a modus operandi here. As the court's aware, modus operandi means literally a method of working. Evidence, Your Honor, that the defendant has committed uncharged crimes with the same peculiar modus tends to identify the defendant as a perpetrator of a crime, a fingerprint, or a signature, if you will. The court may have heard it as a strikingly similar doctrine. An example of such, Your Honor, of a modus operandi type for which another act can be admitted into a trial would be something like a fingerprint or a signature. A serial killer shaving the head of his or her victims after every killing. Taking trophies from every type of murder. That is the modus operandi. That is the exception that the Supreme Court of Ohio contemplates. But the state argues that identity here is absolutely an issue, and that therefore modus operandi is an issue. We would submit, Your Honor, that modus operandi is not an issue. The utility of modus operandi, Your Honor, comes from its connection with the current crime through shared characteristics that make the conduct unique to the perpetrator. Here, Your Honor, the accused perpetrator is Billy Wagner. There is no fingerprint like of someone who is not our client hacking a Facebook. And these are just examples, Your Honor, of the other act evidence that the state is trying to introduce for Mr. Wagner's trial. There's nothing modus operandi about any of the evidence that the state seeks to admit. As far as common scheme evidence, Your Honor, the Hartman case is also instructive on how this court should rule. Other acts that are admissible for a plan or common scheme must be so inextricably linked, and the other acts must be of the nature that they are carried out in furtherance of the same overall plan. Evidence of a common plan design refers to a larger criminal scheme, of which the crime charged is only a portion. That's what the Hartman case held. The Bill of Particulars, Your Honor, informs we as the defense that the charges we have to defend against, specifically the engaging in corrupt activity charge, stems from January 1st of 2016 until November of 2018. The engaging in a pattern, that conduct that is specifically mentioned in the Bill of Particulars, does not encompass date ranges for things such as citing gas, for things such as Jake's controlling nature of Hannah. It starts on January 1st of 2016. For the court's reference, not when Sophia was in the womb, but rather Sophia was 2 years old in 2016. And so as such, there is no evidence of any type of common plan or scheme that the state seeks to introduce with this other act evidence. Your Honor, we would submit that as far as the state goes with Tabitha and Elizabeth Wagner, we would submit that those same arguments stand with respect to modus operandi. With respect to the various other acts that the state argues concerning the Wagners, the state tries to argue the definition of relevancy for proving criminal enterprise or conspiracy in its response. Yet, Your Honor, criminal enterprise, consciousness of guilt are no exceptions to 404B. The court has a blueprint for how to analyze each and every one of these other acts. First is it relevant? Second is, does it tend to show propensity? Third is there an exception, a non-propensity exception purpose? And fourth, Your Honor, it's subject to a 403 analysis, whether or not the probative value outweighs the beneficial effects that hearing these other acts could potentially have on a jury. We would submit, Your Honor, that every single act that the state of Ohio listed in its 2021 notice of intent to produce these other acts they're not relevant, they don't meet an exception, and furthermore, when the court performs a balancing test under 403, they're more prejudicial than probative. Now, when you compare those listed enumerated acts that the state provided us in 2021 to its motion response that it provided to us late last night, there are several ones of those left out. And so if the court would like me to go one by one with respect to the ones that are left out and hear argument on those, I can certainly do that, whichever the court prefers. That's all I have for right now, Your Honor. May I have a moment?
In addition, Your Honor, if I may, it's a situation where the rubric established by the Hartman Court, Your Honor, requires that other evidence be so related to the crime charged in this circumstance that the evidence of the other acts is significantly useful in showing the defendant's intent with the crime charge. And that's on page 58 of the Hartman case. The reason being, Your Honor, for the temporal connection requirement is that the probative value of the other act evidence decreases the more it establishes that between the time of the alleged bad act and the time of the alleged circumstances here. And that's an Apostolate case. And the government's requirement acts, Your Honor, don't have the tendency to prove the crime, or more or less the ones they're putting forth. And I just have a couple for the court. So the timing, as Ms. Stevens indicated in the government's motions, from January 1st of 2016 through November 12th of 2018. They say that my client threatened someone or threatened to kill them. And it's number 4 under the motion on page, there's not page numbers, on the last page indicating general things by my client and his family. Allegations that the defendant attempted to threaten to kill someone before. So the evidence that in the record, Your Honor, in the first trial was such that Jay said when he was a kid getting stitches, that his father said, quote unquote, to the person giving stitches, boy, if you break that stitch again, I'll break your neck. Okay, that's the type of stuff that they got in that doesn't meet any of the requirements under Hartman or anything of that nature, especially the time constraint. There's also stuff about mortgage fraud. There's stuff, each of one you can go to. I'll direct the court's attention to page 2 of some of the acts that Ms. Knupp and the government talks about, and that's with regards to Tabitha Clayton. In Tabitha Clayton, there's 7 listed other acts concepts. But when you take each one apart, Your Honor, and you go to each one in the record, every single time there's a quote, either by Tabitha, either by Jake or Angela, indicating Billy was not involved with that. Billy didn't live there at the time. For the court's awareness, Tabitha lived at the time with George, with Jake, with Angela, and Angela's deceased father's residence. Billy did not live there at the time. Every one of the people, there's a quote, Your Honor. Volume 32, page 7529. Volume 35, page 8313. Volume 16, page 3664. Volume 17, page 3871. Volume 35, depending on the witness, page 8317. All of those, Your Honor, volume 46, page 11089, all of them specifically say about this concept, he didn't live there. He wasn't involved. He didn't have conversations with her. So to impute this to Billy, Your Honor, these are the types of things that when you get to the specifics, it just doesn't make a lot of sense and it doesn't comply with the analysis that the court has to go through, Your Honor. You guys ready?
Come on in, Mr. Hayes.
All I would say is just plain and simple, they put the cards on the table. The state is trying to get this information in to show propensity, to show bad character. That's the sole purpose. There's not a nexus, there's not a connection to the crime in and of itself. You know, that was the basis, although even reading through the first transcript, there was a lot of other evidence that wasn't objected to. But it is a basis of that deal in the first trial as well. And the sign of error, the other evidence wasn't out in. We don't see the connection. The majority of this is all tenuous. It does not connect to the inclination to prove identity or motives that Billy Wagner committed to murder to himself.
Did these issues go up to the Court of Appeals out of George's court?
Correct.
Was there a decision?
I don't believe there was a decision. I can't speak definitively.
Still
but I don't believe there was a decision.
Thanks. One less deal to look for. Your turn, Mr. Knupp. Go ahead.
Thank you, Your Honor. I guess, the state filed its notice of intent to use other acts evidence back in 2021. I recognize that what they have done, I think, is to go through the transcript and, things that came in George's trial that they think should not come in Billy's trial. And the state will readily concede that we agree that some of that will not. We're not at the point where we're seeking to introduce those sorts of things. Lost my train of thought, sorry. But, when, we were saying things like Billy didn't live there at the time, when Tabitha was there. That's not true. There was a time where Billy was living at the Flying W to help take care of his ailing father, but he would still come over to the house every day, and there was testimony that he did arrive at the end of one of the events there. I guess my general position is it's premature for the court to make rulings on these individual issues. I believe the court has said at least a few times that you've been spending some time with the transcript. But until it's offered, some of this stuff I think came in through George Wagner's testimony, which certainly will not be coming in Billy's. I mean, George talked about a lot of other act stuff. But there are things that are, as this court knows, they're charged with a RICO case, which requires the state to establish a criminal enterprise. And, there are going to be things that are relevant to that. The same thing with the conspiracy, Your Honor. In the motion in mind that you do not have, let's see, to help so in other words, because conspiracy requires a meeting of co-conspirator minds on a common criminal objective, other act evidence indicating a co-conspirator state of mind may well be relevant to explain how a criminal enterprise developed, to help the jury understand the basis for the co-conspirator's relationship of mutual trust, or to complete the story of the charged conspiracy. Both Jake and Angela testified in George's case that it was the tumultuous relationship between Hannah and Jake and their obsession with Hannah and Jake's child were the primary motive in the aggravated murder. So again, some of this stuff too, that I, in the notice of intent to use other acts evidence, really isn't even other acts evidence. I just threw it in there out of an abundance of caution. The fact that controlling of the females that come into their life, in the state's opinion, is a behavioral, fingerprint. They have a definite playbook when it comes to dealing with the females, Hannah, May, Tabitha, Plater, and Beth Ann Wagner. And that playbook gets repeated over, and it ultimately culminated in the death of 8 people. Because it was when Hannah May said, I will not sign custody papers ever, they'll have to kill me first, that the wheels got set in motion. That was December of 2015. And by April of 2016, Hannah May and 7 members of her family were dead. As a result of that resistance to the control that the Wagner family exerts. So, I guess, the modus operandi, with some of the arsons and stuff like that, I know the state argued this in Georgia's trial. It's the same thing. They plot, they have a plan, everybody has their role in the process. After the crime has been committed, they work to cover it up and come up with a story, to put out to the masses or to law enforcement should they come around. So, that is exactly what we see going on here. And again, that kind of goes back to that criminal enterprise. They're constantly committing crimes for financial gain or other purposes, in this case, to establish control of this child that was no longer in their 100% control. So again, Your Honor, I think it's hard because at this point we've not sought to introduce anything. I don't think that everything that came into in the George's case, the poaching deer or actually the one thing that Mr. Collins just mentioned, the pointing a gun at somebody. We never put that in George's trial. In fact, I would say that number 3, instance of defendant threatening Angela Wagner with a gun. Number 4, this is under in the notice of intent to use other acts evidence with kind of the general catch-all thing that I have at the end of that. Allegations that the defendant has plotted, threatened to kill others before. We did not bring that into evidence. I would not seek to introduce that. defendants' involvement in transporting drugs and engaging in drug trafficking. We know that the story of the night, at least according to Jake's testimony, was that, they were meeting Chris to do a drug deal or to firm up plans for a drug deal. We think that was a fictitious drug deal, but that Chris Rhoden believed was a real, so there are some of those fringes, but again, at this point, we are not, seeking to admit all of these things that are listed here. But the ones that we would be seeking to dismiss, Your Honor, again, specifically relating around, and I would also say that it's certainly relevant, because again, that is their motive. It also goes to their motive, which is another permissible use of other acts evidence. And they freely admit that was. It's proof of motive. Opportunity, intent, preparation plan. That the controlling of Hannah Mae was their motive when they found out that she was going to resist that. So, some of this stuff is extremely relevant and goes to making it more probable than not. And I would also say it is not so inflammatory or prejudicial. It's not like I'm saying, oh, he killed somebody else, or he did this, or he did something really horrible. But they would be like, oh, well, he did that, and he did this, which is the concern with impermissible or acts evidence. That's the propensity stuff. Not in this case, in this case. First of all, some of it is just to tell the story, and I have that quote, and I don't know what it is. But, to complete the story of the charged conspiracy, but it tells you evidence shows that the tumultuous and strained relationship with Hannah, and more specifically the Wagner's motive in committing the aggravated murders, the murders were the final culmination of their jealousy, possessiveness, and control. And that is it can be relevant just to give background and relationship on, or information on the relationship and as it developed. So again, some of this I don't even think is other acts evidence. Some of the more specifics, when he's saying, well, Billy wasn't there, or this or that, I would agree in some of those instances that would not be permissible. But again, there are times where, they all conspired to commit these murders. They all were doing separate acts. They weren't always together when they were, buying the murder truck or building the silencer or, making purchases. So from those aspects, I think those pieces of evidence would
Mr. Bryan?
Listen, if I want to go ahead, say your name, of course, since I came all the way down here to Pike County today and sat in the corner this morning. I'd just like to say, I think the one word, and I'm not sure we used it, premature, I think, is a guidepost here. Some of the things, obviously, that are identified by Mr. Collins' motion, certainly, if they were used in George's trial, won't be used in Billy's, by my view, but I had not been through this transcript, and some of the other things that Mr. Collins identified that he wasn't there. So what? I could hire him to commit a murder, be in New York City, and the murder happened here, and the fact that I wasn't there when it was committed is irrelevant. And certainly, if I'd done that 6 times before because I'm a monster trying to kill people off in a drug conspiracy, me being there or not being there, or living there or not living there is totally irrelevant to whether or not other acts is admissible. So at least I think I understand what Mr. Collins' concern is, and understand that the court doesn't want the state to go astray from what the counts are in the indictment with other evidence of acts that the Facebook, for example, surveillance that might constitute telecommunications fraud is a county indictment. That's not another act. So that clearly would be admissible. The forging of documents on birth certificates is a county indictment. That's not another act. So I think they have mixed together certain things, claiming them to be other acts when they aren't other criminal acts by the defendant that be, but rather they're state's evidence to prove the count in the indictment. So that again goes back to where I started, that I think if the court's going to review this and write a decision with certain broad guidelines, that might be a topper, but otherwise I think that it really is premature. And I think at the last hearing, Mr. Collins even said that this was something that might be able to be considered through the flow of the trial as the issues arise. So unless the court has any questions, I would have nothing to do about that.
Thank you, Mr. O'Brien. Appreciate it. So I articulated my reasons for saying that the death penalty specification should be dismissed. Number one on the list was listing to lawyers, seemed to make that an easy no-brainer, and then I found out that listing to lawyers isn't always advisable. Or when we do so at our own risk. So that was the beginning of a cascade downward into the Court of Appeals, which is fine. I appreciate the fact that they can help guide trials along the way. But Mr. Knapp, I thought that that was like without enough notice. So if you want to have a record, you're welcome to caution me about not believing what lawyers tell me. So you want to straighten me up. I set the death penalty aside because I heard for months, Mr. O'Brien, that the lawyers, you were here, would actually, 100%, yeah, I appreciated the fact that you were willing to encourage me to delay and give you some more time, and maybe that's still appropriate, but I did grab a hold of the fact that you thought you didn't have adequate time to argue, so I gave like the obligatory 10 points, literally 11 points, about why that seemed to be necessary and appropriate. And if she didn't get enough chance to answer all those points, I'm going to revisit that just so like I can make sure she can advocate. So just picked up and said we're all here. The court reporter's got fresh fingers. She can write down whatever Ms. Canepa would like to do to set me straight. Well, I only acted in like reliance on lawyers, not hoping to embroil the Court of Appeals in what I already called invited error, but that's at a different level. So stalled me for listening to you, actually.
Well, at least, Judge, I think my view is that since the notice of guilt was filed, that the state would not be able to add or supplement the record, or the court would not be able to do so either.
But my notice went on before yours that I was going to reconsider. So you don't maybe have a final order. I can still hear this. I don't have to act on it. But in fairness to you, I'm not going to interfere with the Court of Appeals. I said to you all I wouldn't interfere with the appeal, but I would keep this trial moving. I didn't cancel any dates. We got a lot of work to do. So while the Court of Appeals is doing its job, I can still have the second track. But if I went afoul, then we still have time to fix me. So fix me.
Well, at least, Judge, I think that it's proper for the court to hear this motion under 404B to eliminate today, because that doesn't involve the issue that's in front of the Court of Appeals. But at least my view is since the issue on whether a death spec should have been dismissed under those circumstances at the time is in front of the Court of Appeals, that we would not have jurisdiction or ability to supplement the record, argue the record, for the court make other findings or defense present something further. So at least with that view, I don't think the state would have any further to present.
So like my understanding is I can't act in contravention of the notice of appeal. But hearing argument, taken under advisement, is not an act. This is how I see the law. Like I wanted you to have the opportunity to make your record so we don't have to schedule another hearing and waste more time, have further delay. So I won't act on this. I will just hear this, take it under advisement, let the Court of Appeals give me further guidance. Like I expect lawyers to be doing 5 different tracks of work simultaneously, not one thing at a time, followed by one thing at another time. Otherwise, we don't get anywhere. So like I run 4 different railroads going the same direction. And that's what I think we have to do, is run multiple actions simultaneously. So I would invite you to like help me understand better how it is I went foul so I can fix it faster to keep the railroads running. And if you don't want to argue,
Well, exactly. I think the only thing you could have set aside that your dismissal of the test acts, and now we didn't hear with
No,
the restriction of the court's opinion.
if I did that in advance of their decision, maybe, because it's not contrary, in essence, I'm giving you the trial level, I wouldn't do that, I told them, I'm not going to do that. But like, you don't want to argue now what you wanted to argue before, I'm not going to make you argue, but I might not give you another bite at the apple later. I might call this a waiver if you don't want to give me the argument today. I'm not saying what I'm going to do, I'm just saying there's 4 railroads running the same direction simultaneously. That's how I work. So I would be curious in having this railroad loaded up and ready to go while I'm working on the other railroad, other acts testimony, while I'm already working on jury instructions, while I'm already getting ready for a different venue. There's more than 4 railroads running one direction in my mind, and if everybody's used to doing one at a time, shame on you. Because we can't. Nothing personal. But I run into a lot of lawyers who can do one thing at a time before they do the next one thing at a time. And that's why they're slow. And that's why I can't do that, because like I'm here to get this case done properly, timely. So I want to run like multiple railroads.
Well, I think that's proper, Your Honor. I guess the railroad dealing with whether defects are in the indictment or dismissed is out of your hands, in my view. That railroad is in the 4th district. Is this the 4th district?
Okay, so you don't want to argue further. Okay, good. I'm not saying I won't give you another hearing. I'm trying to be efficient.
Okay, well, I understand and appreciate that.
Yeah, no, 100%. I'm trying to be efficient. Like I got everybody here on a date that was scheduled last June. We're right where we're supposed to be through today. Let's use the time. But I get what you're saying, so you can be comfortable, sit down.
Okay, thank you, Your Honor.
Your respect was appropriate, as I would understand, Mr. Ryan. Thank you for that. You don't have to. I'm going to go to Mr. Collins or whoever wants to speak to it from your side. I don't care. I'm just trying to give you a chance to make a record.
Please support, John. I don't believe you ran a file. At the prior time, we had filed a motion to dismiss the death penalty specs based on the agreement that was made by the government and Jay Tiger. The representations that were made were consistent since you've been involved in the case. There were some misrepresentations made by the government in their motions to file. Specifically, our client knows the government's listening to every one of his phone calls, so he likes to mess with them, so to speak, and things of that nature. So, but we were in good faith. We've always been in good faith, and our client in our communications that I can't go into was acting in good faith as well with us, and we were all on the same page. So, I've had communications since that indicated they would give me a thing, give me another, give me anything. I've never had anything. It's just a shutdown since that day of the hearing. So we believe that. We don't have a lot to argue, Mr. Hayes.
The only issue that I have is when the state responded, after they reportedly listened to some of the Billy Wagner's phone calls, which we never received, there was an insinuation that we were always acting in bad faith. And that's absolutely false, and we take issue with that. Without getting into the communications with Mr. Wagner, we acted in good faith. We were proceeding in good faith. We had the intention to go forward with the trial in the state with the death penalty specifications off the table. It, in essence, deprives us, we believe, of due process to try this as a capital case. Halfway through the trial, they removed the death specs. So we were in agreement to do that. There was communications with the state. They were going to get us back another record. We never received that, and we were here before the court. But it was another agreement. It was our intention to have that completed before that court date. So at no point in time was there any bad faith on the defense, and that's what I take issue.
Thank you very much.
John, if I may,
Yeah, go ahead.
certainly, this case was started as a court notice on November 20th.
seems like the feed,
At least was saying on jail phone calls that he was not going to enter into any sexual agreement.
Thank you for that credible statement.
Yep, looks like the court feed is having some issues, chat. So hang in there. I've been messing with the audio. It's kind of hard to work it, so sorry, Dwayne.
So I'll acknowledge that the other act's decision is likely to be couched in terms of an in limine, as it should be, advisory opinion. For everybody in the back of the room that don't speak, lawyers speak. We're trying to decide in advance what's relevant evidence. But the reality of it is you don't make that decision until you get to the courtroom and have the full context. So when they
So the court feed is having some
That's
issues,
what
guys.
we're
Just hang
trying
in
to
there.
sort out. It has a lot to do with the nature of the charges, has a lot to do with the scope of the indictment, but it's going to be advisory. It does help because, frankly, we've got to make sure we're efficient when we try the case. There's no sense bringing in a witness from someplace that's going to take the stand and find out in 30 seconds everything they want to say is not coming in. So I'm pretty much a harper on making the railroad.
More problems with the feed, chat. Just hang in
Understand
there.
the scope of the trial.
Mayor,
Go ahead.
please, the court, with regards to, would you want a written response to the government's motion from us? Would that help, or?
Yep, just hang in there, chat. The court feed is basically frozen right now. So not much we can do. Yeah. Oh, they're back.
Is it 10 days okay for time to respond?
Are you going to do the work for somebody else?
Ms. Stevens is going to do it.
It's 10 days.
Thank you, Your Honor.
I like to what you asked me.
Yep. So, wah, wah, wah. I guess we'll just hang in until it kicks in. Therapists, you know, you say this happened the other trial too.
Looking at the indictment, how to get a different motion later on under Rule 15 and 17, wherever they are. Then the whole apple cart goes up in the air. I don't know the answer. I'm just saying anything I give you is always going to be subject to wherever we are at the moment. Good luck to me. When we get a decision from the Court of Appeals, whatever it might be, I don't expect to give you the luxury of a lot of time. With all due respect to any other judge who's anything other than short term.
All right, we're going to switch feeds, guys.
Everyone,
Let's see if this one is any better.
it is.
All right. Hang tight.
I do is going to make everybody else's life uncomfortable. Thank you for the offer. We're not going to get both ways.
Sorry, I can't speak for Mr. Hayes, or Mr. O'Brien, Mr. Neville, but I know I have I know the month of March, and the end of February, month of March is a police shooting. Entire month of May is a police shooting. Entire month of July is a police shooting. I'd be happy to go in between, but any help the court may give, those individuals are out and not in custody, so any help that the court may be able to give to take up some of that time. As long as we get your help, we'll do whatever the court asks us.
Anything I do is going to make everybody else's life uncomfortable. Thank you for the offer. I know it gets both ways, 100%. I'm going to call any judge and scream at you, and you. I'm more than happy to call. So I'll let you use your judgment, because I don't know what it says, and I'm always interested in being better educated.
Is it 10 days okay for time to respond?
In the courtroom and have the full context. So when they ask me to do something at this stage with admissible evidence, it's only my best guess. And we all acknowledge it's my best guess based upon the law and the application. So that's what we're trying to sort out. It has a lot to do with the nature of the charges, has a lot to do with the scope of the indictment, but it's going to be advisory. It does help because, frankly, we've got to make sure we're efficient when we try the case. There's no sense bringing in a witness from someplace that's going to take the stand and find out in 30 seconds everything they want to say is not coming in. So I'm pretty much a harper on making the railroads run multiple times very efficiently. So I'll give you that decision in limine. I think I can help you understand the scope of the trial.
Mayor,
Go ahead.
may I please the court with regards to, would you want a written response to the governor's motion from us? Would that help, or would you think you have enough to?
You have to call that, because I can never tell you what not to call. I always appreciate the help until it's not.
We'll try to do something.
So whatever, I haven't seen what it is, I don't know what I need. But when people ask me if I should file something, the answer always is, I don't control the document, you do. So I'll let you use your judgment, because I don't know what it says, and I'm always interested in being better educated.
Is it 10 days okay for time to respond?
Are you going to do the work for somebody else?
Ms. Stevens is going to do it.
It takes 10 days.
Thank you, Your Honor.
I like to do what you ask me. One aspect of the other act testimony is in my mind, but not before the court, and that's what charges get tried. And I don't want an answer from the defense about whether there's a severance motion coming. I'm not asking for anything. But like if I issue an in limine decision, looking at the indictment, and I get a different motion later on under Rule 15 and 17, wherever they are, then the whole apple cart goes up in the air. I don't know the answer, just saying anything I give you is always going to be subject to wherever we are at the moment. Good luck to me. When we get a decision from the Court of Appeals, whatever it might be, I don't expect to give you the luxury of a lot of time. With all due respect to any other judge whose document was submitted to you, I'm more than happy to call and say, here's my problem, which just was made yours. That's not a commitment to anything other than short term, whatever short means.
Would the court have any indication of what short means? Only for, I can't speak for Mr. Hayes, or Mr. Wagner, but I know I know the month of March, and the federal month of March is a police shooting. The entire month of May is a police shooting. The entire month of July is a police shooting. I'd be happy to go between, but any help the court may give, those individuals are out and not in custody, so any help that the court may be able to give to take up some of that time. As long as we get your help, we'll do whatever the court asks us.
Anything I do is going to make everybody else's life uncomfortable. Thank you for the offer. I know it gets both ways, 100%. I'm going to call any judge and scream at you and use my best manners to explain my problem. But that's not resolving the problem, just saying we have to understand that busy lawyers have multiple commitments and schedules flex the whole time. But short is all I can say, and I don't know the answer to that. I mean, it's not, I don't have that consideration. I have jury commissioners, I have deniers, like I'm way out ahead of you because you don't have to be out there. But I do. Thank you for submitting your proposed jury questionnaire. Twice edited. Oh, you don't know that. I'm probably not going to give you a chance to argue it either. I'm just going to do what I got to do to get there. Thank you for helping me. Seriously, we're making progress. Everything that happens in the room isn't everything that happens. I proved your fees today. Further proof that everything that happens in the courtroom is not everything that happens. There's both sides of the room. It's 100%. Everything you have to do has to get done outside the courtroom also. So you're probably running more than one room side. I'm totally running. And I don't have one case. You don't have one case. We all have to run. Does anybody need the record for anything else? Ms. Canepa?
Yes, Your Honor. I don't know if the court, given none of us knows how the Court of Appeals is going to rule, or if somebody's going to appeal that decision. Obviously, none of us knows what's going to happen. But I know the concern was mitigation had been stalled out. I don't know if I know the courts, defense attorneys are allowed to talk to the court ex parte about fees for experts or whatever. I don't know how much they got done. This case was indicted in 2018. I don't know how much they got done before. Jake,
What's there to mitigate?
Well, that's not for me to decide. That would be for a jury to decide if it proceeds.
It's 100% for you to decide because you're the one telling me we're not going to need mitigation. So either you intend to keep the death penalty all the way through, or you intend to remove the death penalty mid-trial. So now you're saying it's definitely not negotiable. I want to know if it's not negotiable.
Oh, no, I'm not saying that at all, Your Honor. Okay,
So there won't be a need for mitigation if there's no death penalty.
as long
right?
as Jake testifies, right? That's the condition. I just like George's trial, I agreed to dismiss, his defendant's agreement says that I will dismiss the suspects if he testifies. If he doesn't, then I would not. So that's not that's always been the case. That's never been different.
Talk to all those people out there, because I don't read social media, but like every time I get more information about the done deal dismissal withdrawal, it helps me understand the validity of the statements that we're not going to be doing this. Like every time you come in and tell me more about ethical problems, ineffective assistant counsel, and now here's the terms of the agreement, I better understand how you were all too optimistic in your assurances that we weren't going to be there. So I'm not going to, I get your problem. I'm not going to have that answer. I would consider that a strategy. So thanks, you have a different time.
Yes.
Go.
I would like to amend the bill of particulars. The count 6, 7, 8, and 13 should say Scioto County. It's in the transcript that they were provided, if they provide the transcript, 2023 sometime. But when, the court asked for the bill of particulars, and I was looking through it myself for the other act stuff, it's possible I've done that already, but I don't know that I have done that. So I would move to amend the bill of particulars.
How do you want to handle that? This is year 9, right?
Sorry?
This is year 9. We're coming up on the 9th anniversary, right?
Charge 18.
Yeah, the facts happened in 16. Okay. I'm just like being a little bit snarky at the moment because I can see it from your face, so why don't you just have at it? The indictment's in 2018. I understand the bill.
Well,
The bill.
what I was going to say is that the lead-in language to the indictment says that within or the body of Pike County or some manner enumerated in 290112 of the Ohio Revised Code where the proper venue is placed in the county of Pike on their oaths in the name and by the authority city. So
Yes, how do you want to handle the request for amendment? You want it in writing, and then you get a response in writing?
Yes, sir.
Yeah, like, I get where we are, didn't see that one coming, but that's why I asked for Bill to take this. Like, I'm to the point now where I can drill deeper into all the stuff that you're years ahead of me on, get back to your head. So if she's gonna file a written motion to amend the bill particulars, and you want how much time? Okay, and then how much time behind it did you want for your very capable staff?
7 to 10 days.
Okay, we'll have a good, solid record of what we're asking for. Anything else you want? Mr. Bryan looks like he's got one.
No, I was asking Ms. Knapp if similar to the court letter, there was anything in the position. So I have nothing further, thank you.
All right, anything else?
Oh, thank you very much.
All right, thanks again to the court staff. Go ahead and stand adjournment. Oh, no, we won't. Let's talk about our next scheduling. Phone call, do that. You want to do it right now? Go off the record, just get our calendars and phones and things like that. Doesn't seem to be a good way to ease things. We still have that case where we have 3 weeks. Now we're not going to be there the other week. Or where are we with? Sometimes I get in the way, so you don't need to do that.
I would think 6 weeks. You're the one with the busy schedule.
The judge, this is special, not every other week, maybe a few, but 6, that's what it's about. Why don't we first start with a month from now, and then I think we should all be doing it. The opinion comes back, it's on that, then we do more, so we need to set them now, and then continue to find the opinion.
When 4 happens, it's going to be like 0 to 150. Right? So like before you can be ready for the acceleration.
Right.
At some point, there isn't going to be time to be ready. There's just going to be time to go. We're going to go.
Last week,
Like I'm down to think comes to see you. Think of yourself as a card. Or it might be anyway.
Brady, can I courtroom judge or is your call?
No, we're going to just do it. We're going to like have it. I'm pretty sure I'll be fine with things I need to do. Yeah.
Okay. Because you mentioned the call.
Then I was thinking we could call the schedule, but you don't have the phone calendars.
that Friday morning.
I can do that.
And
We have 2 years.
not good for you? Oh, that's right. Right, so since it's got to be like relatively non-controversial, it must be you said that, yeah. You got
those two releases. And they go into our No, she's
We'll get along just fine.
okay. Well, I'm sorry, what day did you say?
I think they can't do that, right?
She said it's just
I'll see if I can get Cassie.
We're going to do other stuff. We're going to do other stuff. Did you read my statement? Decision. The first half that I would respect to stay on the issue of some appeal, I should. The second was I would not stay all around. I didn't pick the time. I don't know.
The one they used to
I
charge.
keep finding out from you guys what else is out there every time I wait.
What are you laying on the floor to take that picture? Oh, she's so good. She knows how to bait these Wagners and get them to look right at her lens. And he said, have you been saved by Jesus? I can't believe that judge.
We're all in position. I'll see you next month. I'll see you next month. Yeah. He's ready. March is out.
So those are two.
I wish you could have practiced on a regular basis.
No,
Everybody knows that I have my pictures running. The bigger the trial, the more you have to test it. As much as you might not want to.
Okay, so it's both you.
Yeah. Follow the closely by.
Well, that was, wait, hold on. Sorry, guys. Sorry. That was aggravating, wasn't it? No schedule. He's off the bench scheduling. Rafa's taking a nap over here. Paulie's being all Paulie. Giddy. Did I get a toe stamp on that for a replay? That was like really annoying and very frustrating. All right, I'll go over what we did here. So it's a motions hearing, and it was about the Hartman case. They kept talking about that, and it was what was inadmissible and what's admissible. So basically, Billy wasn't an actor of the other acts. He was not present. He didn't take part in the conversation. He lived with his mother at the time. State is trying to get this to show bad character and has nothing to do with the case. Nothing to Jake testified that this was a drug deal, but then they think that that was false. Oh, have I been muted the whole time? Sorry, guys. All right. Sorry, guys. Let me try that again. This was a big waste, to be quite honest. We didn't really get much. I don't know what you heard and what you didn't hear, but
Just hang on.
basically, they were talking about inadmissible evidence, that Billy wasn't an actor, he was not present, and he didn't take part in the conversations, and he lived with his mother at the time. Nothing to prove identity or motive. Then they talked about conspiracy in RICO and a criminal enterprise. I think it was a criminal enterprise because there was the father, the mother, mother-in-law, and 2 sons were involved. Maybe. I don't know. Hannah said, I'll never sign any custody papers. You'll have to kill me first. And she said that December 2015, and then in April, she was dead. And then Jake testified to a drug deal, but he thinks that that was false. Sorry, that was for you, Jennifer. How about an as an okay? I don't know. This was just kind of a big nothing burger in my opinion. I'm sure every other lawyer out there could break it down, but I'm no lawyer and I'm not going to be able to break down what just happened. I just want to know when the next court date is heard, and then the judge gets off the bench. I don't know. I am very dissatisfied right now. So anyway, we're gonna do Todd Mullis in about an hour, right? 3 o'clock.
Oh, I was gonna just do it now.
I gotta talk to Brian.
Oh, okay.
All right, I gotta make a phone call, and then we'll do Todd Mullis. So let's pick up on Todd Mullis at 2:30. Is that cool? If you guys want to join us over at Todd Mullis, he's the corn rake. Allegedly stabbed his wife Amy in the back. He says that she fell. They're hog farmers out in Iowa, so it's pretty interesting. All right, so join us then. Sorry for the but I don't have 3 masters, so I can get away with doing ums. I don't even have a bachelor. Ha! All right, I will see you guys. I'm going to say goodbye for now. Got to make a phone call. I'll see you at Todd Mullis in a little bit. Erin, are you going to do a redirect?
It's already.
Erin has already done a redirect. She is the bomb. You guys have no idea what she does. All right, thank you for joining us. I'll see you guys at Todd Mullis in about 15 or 20 minutes, 2:30. Okay, thanks for joining. See ya. Bye.